Good evening. Welcome to Deb's True Crime Notebook. Once again, it looks like the defense has filed an interlocutory appeal. So let's find out what that's all about. Motion for court to certify court orders for interlocutory appeal pursuant to Appellate Rule 14 and request to rule expeditiously on said motion. Comes now the accused, Richard Allen, by and through counsel, and moves this court to certify the September 4th, 2024 court order granting the state's motion that prevents the defense from presenting certain evidence, and the August 28th, 2024 order denying the defense's motion to suppress certain statements made by Richard Allen. For interlocutory appeal pursuant to Indiana Rules of Appellate Procedure 14. Furthermore, the defense would request this court to rule expeditiously based upon the October 14th trial date. In support of said motion, Allen states the following. 1. The Indiana Supreme Court has recognized the orders in limine have historically been eligible for interlocutory review. Orders in limine are eligible for discriminatory interlocutory appeal. Means 2 versus State 201 NE 3D 1158-1165 2023. Orders in limine are eligible for appellate review under Appellate Rule 14b to the same extent and with the same prerequisites, trial court certification and Court of Appeals acceptance as any other interlocutory order. The tentative nature of orders in limine does not result in the categorical exclusion of those orders from discretionary interlocutory review, which is why our appellate courts have long reviewed orders in limine through interlocutory appeals. ID at 1167. 2. In the past, interlocutory appeals concerning motions in limine have also been allowed to the benefit of the prosecution. See State versus Harold Lewis, 883 NE 2D 847, Indiana Court Appellate, 2008. After the trial court granted the defendant's motion in limine, the state of Indiana received an order in limine preventing the prosecution from presenting certain evidence. The trial court then certified the order for interlocutory appeal, and the Court of Appeals then accepted the order for interlocutory review, ultimately reversing the trial court's ruling. 3. The denials of motion to suppress are also eligible for interlocutory appellate review. See Kelly v. State 825 NE 2D 420424, Indiana Court Appellate 2005. Direct review of the denial of a motion to suppress is only proper when the defendant files an interlocutory appeal. The defense, number 4, the defense contends that the court's September 4th, 2024 order denied Richard Allen's right to present a defense in violation of the Sixth Amendment to the United States Constitution. 5. Furthermore, the defense contends that the court's September 4th, 2024 order denied Richard Allen his constitutional rights of the following provisions of Indiana Constitution. A. Section 12. All courts shall be open, and every person for injury done to him in person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. B. Section 13A. In all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed, to be heard by himself and counsel, to demand the nature and cause of the accusations against him, and to have a copy thereof, to meet the witnesses face to face, and to have compulsory process for obtaining witness in his favor. See Section 19. In all criminal cases, whatever the jury shall have the right to determine the law and the facts. 6. Furthermore, as to the alleged confessions of Defendant Allen, the defense contends that the court's August 28, 2024 order denied Defendant Allen of his 5th, 6th, and 14th Amendment rights under the U.S. Constitution, as well as his constitutional rights under Article 1, Section 12, 13, and 14 of the Indiana Constitution. 7. If this court has erred and the determination of the error is withheld until after judgment, then the appellate victims' families and citizens of Carroll County will suffer substantial expense and damage as follows. A. Richard Allen will suffer continued incarceration while awaiting the ruling for the Court Appeals. B. If Richard Allen is convicted without interlocutory appeal, then he, as well as the families of the victims, would first suffer through the anticipation of a ruling from the Court of Appeals or Supreme Court on these critical issues, and then whether a reversal will result in a secondary lengthy trial. If the appeal in regular course, not interlocutory, results in a reversal, then Richard Allen and the victims' families will have to endure a second lengthy trial. C. Also, the taxpayers of Carroll County will suffer substantial cost, perhaps in the millions of dollars between appellate cost, attorney's fees, expert cost, and cost of security in 2 different counties based upon a second trial, as well as time of all the parties involved, including the trial judge, prosecutors, defense attorneys, law enforcement, family members of the victims, and others who will all sit through the lengthy second trial. Additional cost associated with the sequestering a jury during a second trial would also be significant in both expense and time. D. Moreover, the prosecution of defendant Allen has brought about worldwide attention in nearly every form of media coverage, as well as extensive coverage by various social media platforms. The disclosure of facts and information, including many facts unknown to the public, even to this day, at a jury trial, will result in the consumption of this information by these reporting sources. The dissemination of this information to the public, which will undoubtedly occur, will make it more difficult for the defendant Allen to find unbiased jurors in the event of a retrial. E. Defendant Allen's detention circumstances are unlike any other pretrial detainee, perhaps in the history of the state. He has been and continues to be isolated from any sense of normal contact with the outside world, with the exception of his ability to make monitored phone calls to his family. This has been the case for nearly 2 years, to the extent a retrial would occur. Defendant Allen's detention circumstances would place further burdens on him and the facility in which he is housed. This workload would be compounded and would likely require months and months to organize, review, and prepare for a second trial. F. The voluminous discovery offered by the state, deposition transcripts resulting from discovery conducted by the defense, and mounting number of transcripts stemming from the pretrial hearings have resulted in a monumental amount of trial preparation for both the state and defense. G. If a second trial were to occur, the compounding of discovery, transcripts, and other related materials stemming from this case would place extraordinary burdens on the state, defense, victims, families, defendants, and defendants' families. Not to mention the judge and court staff members in both Allen County and Carroll County. Law enforcement officers from the various investigating agencies would be required to continue to exhaust their time and resources, even beyond the 7 years that has already passed since the crimes were committed. And finally, the additional expense to be borne by the taxpayers of Carroll County would continue to mount. It is for these reasons that an interlocutory appeal addressing the issues of defendant Allen's pretrial detention and incriminating statements allegedly made by him thereafter is appropriate. H. Additionally, should this court not allow these issues to be heard by the courts of appeals in an interlocutory fashion, then during the jury, set to begin October 14, 2024, the jury will be sitting for hours or perhaps even days while the defense presents its evidence and an offer of proof, whereas should the Court of Appeals find that the trial court was in error, then the jury will not be forced to wait outside the courtroom or in the hotel rooms for hours or even days while the defense presents its offer of proof. The trial will run more efficiently and at less expense should these issues be resolved by the Court of Appeals before any trial takes place. 8. This court's August 28, 2024 order and September 4, 2024 order both involve substantial questions of law, and the early determination of those issues will promote a more orderly disposition of the case, to wit, The September 4, 2024 order denies Richard Allen the ability to present a defense, violating both state and federal constitutions. 9. On September 18, 2024, the defense filed its first Frank's notice, at which time the defense revealed in great detail its defense that Odinism, Norse paganism explained the unusual nature of the crime scene, and furthermore identified particular suspects who were tied to the victims and or tied to the crime scene. 10. The September 18, 2023 Frank's notice was very transparent and left no doubt that the defense would be claiming that A. Odinism, Norse paganism were involved in the murders of the victims. B. Law enforcement began investigating the links between the crime scene and Odinism, Norse paganism, within 3 days of the murders. C. That the law enforcement began investigating Brad Holder and Patrick Westfall as suspects within 3 days of the murders. D. That at least 3 law enforcement officers continued to investigate it into the Odinist Norse paganist ties to the murders, and particularly ties between Brad Holder, Patrick Westfall, and certain men in Rushville, Indiana, to the murders. E. That Richard Allen had no connection to Odinism, Norse paganism, and therefore could not have left signatures of Norse paganism at the crime scene. 11. In spite of the prosecutor knowing defendant Allen's third-party defense on September 18, 2023, the prosecution waited over 7 months before filing its motion in limine on April 29, 2024. The prosecution's motion was filed 15 days from the May 14, 2024 trial setting. On April 29, 2024, the prosecution filed its motion in limine, requesting in paragraph 7A and 7B that the court prevent the defense from presenting evidence that explains the defense's belief of what the crime scene shows. For example, that certain signatures the killers left of the crime scene revealed that a ritualistic killing occurred at the hand of a Norse paganist Odinist. Because Richard Allen has no ties to Norse paganism nor Odinism, the evidence of the state of Indiana sought excluded would prevent Richard Allen from arguing that Richard Allen did not commit the murders, as he knows nothing about Norse paganism and therefore would have had no motive nor knowledge to leave signatures of Norse paganism behind. On August 1, 2024, the defense presented evidence through expert witness Don Perlmutter that the crime scene was a textbook ritualistic killing. This opinion was offered from an expert who literally wrote the book on analyzing a crime scene for a ritualistic murder and also has taught FBI and other law enforcement agencies all over the country what a ritualistic crime scene looks like. Furthermore, Dr. Perlmutter has also almost exclusively worked for law enforcement and prosecution, not the defense. The jury would be able to assess the weight to give Dr. Perlmutter's assessment of the crime scene. 12. Furthermore, in its April 29, 2024 motion in limine, paragraphs 7C, 7D, 7E, 7F, 7G, and 7H, the prosecution requested the court to prevent the defense from presenting evidence that tied alternative suspects involved in Norse paganism, Odinism, to the murders, including evidence of the investigative efforts of 3 law enforcement officers who believed that the evidence credibly pointed the finger to certain third-party suspects, and also social media posts that provide a nexus between certain third-party suspects and the murders. Furthermore, in its April 29, 2024 motion in limine, paragraph 7I and 7J, the prosecution requested the court to prevent the defense from presenting evidence that third-party suspect Kagan Klein and Tony Klein committed the murders, even though credible evidence existed that A. Kagan Klein had arranged to meet one of the victims on the day of the murders, B. Kagan Klein implicated his father, Tony Klein, as being involved in the murders, C. Law enforcement tried to tie Richard Allen to Tony Klein and arguably only interrogated Richard Allen because of law enforcement's initial belief that Tony Klein and Richard Allen knew each other and committed the crimes together. D. Law enforcement officials discovered a cache of child pornography on Kagan Klein's personal cell phone during the course of the investigation. and E, law enforcement officials actually transported Kagan Klein to an area near the crime scene to corroborate his version of what he and his father, Tony, did near the crime scene on the day in question. 14. Furthermore, in its April 29, 2024 motion in limine, paragraph 7K, the prosecution requested the court to prevent the defense from presenting evidence of third-party suspect Ron Logan, even though credible evidence existed that A, the bodies were found on Ron Logan's property, B, an FBI-authored probable cause affidavit stated that Ron Logan, I, placed a phone call on or around his property around 2:09 p.m. using cell phone tower data, Ron Logan provided false information about his activities during the times the crimes were committed and employed others to assist in deceiving law enforcement, and furthermore plotted an alibi for a crime that had not yet been discovered. A court found that said probable cause affidavit provided probable cause that the evidence of the murders would be found on Logan's property. 15. Furthermore, in its April 29, 2024 motion in limine, paragraph 8, the prosecution requested the court to prevent the defense from presenting evidence from law enforcement officer Todd Click, who investigated the Norse paganism Odinist ties to the murders, as well as the ties of certain third-party suspects to the crimes, primarily those identified in paragraph 7A through H of the state's motion in limine. Click's testimony would provide evidence that connects those third-party suspects to the crimes. As with the testimony of law enforcement Kevin Murphy, who also investigated said connections alongside Click, including testimony that Elvis Fields posed the question to him of if his, that is, Elvis's spit, would be found on one of the girls, but he could explain it. Would he, Elvis, be in trouble? Furthermore, Murphy would be able to tie Elvis Fields from Rushville, Indiana to Brad Holder of Logansport, Indiana, and that Brad Holder was an active Odinist whose son, Logan Holder, dated one of the victims and who also has changed his story multiple times about whether he had ever met the victim, and whose social media post included evidence that tied Holder to the crime scene. 16. Furthermore, in its April 29, 2024 motion in limine, paragraph 9, the prosecution requested the court to prevent the defense from presenting evidence of geofencing, even though that geofencing evidence provided evidence that other third-party suspects were in the area of the crime scene at the time the prosecution is claiming that the crimes were committed. 17. After the May 13, 2024 trial date was continued, the court held the hearing for said motion in limine on August 1, 2024, and likely because of the voluminous amount of evidence is received and reviewed, the court was unable to rule on the state's motion in limine until September 4th. 2024, which was 40 days before the scheduled October 14, 2024 trial date. 18. Included in the court's ruling was the court's belief that the admission of the evidence would confuse the jury. The defense respectfully rejects that premise. Evidence that the court excluded from the jury would actually provide the jury an understanding explanation of why the crime scene appeared the way it appeared. In fact, the defense would argue that keeping the evidence of Norse paganism from the jury, the jury, would be confused as to why the crime scene appeared the way it had appeared. Additionally, the inclusion of evidence of third-party suspects as being connected to the murders is not confusing, but rather easy to understand, and that it is up to the jury to either accept or reject the defense's contentions that the evidence connects Norse paganism, Odinism, and third-party suspects to the crimes. 19. Essentially, with the September 4th, 2024 order, therefore 40 days before the trial scheduled to begin, Richard Allen's defense was completely gutted. 20. Certainly between the Frank's notices that have been filed and were made part of the record and the exhibits that were attached to those filings, as well as the evidence and testimony in this court received during July 30th through August 1st, 2024, hearings, the Court of Appeals would have more than enough record to review to either support or negate this court's August-September 4th September 4th, 2024 order, as well as the August 28th, 2024 order. 21. The issues to be presented to the Court of Appeals for interlocutory appeal concerning paragraph 7, 8, and 9 of the State of Indiana's April 29, 2024 motion in limine would all involve whether the trial court was correct in granting the state's motion in limine, thereby denying the defense the ability to present evidence, A, concerning its interpretation of the crime scene and how said interpretation excludes Richard Allen as a suspect, B, concerning whether nexus existed between certain third-party suspects in the crimes, and C, whether evidence presented warranted the court from excluding geofencing evidence. The August 28, 2024 order denying defendant Allen's request to suppress incriminating statements violates Allen's state and federal constitutional rights. 22. On November 3, 2022, Judge Benjamin Diener issued a safekeeping order which resulted in the defendant Allen's immediate transfer to a maximum security IDOC confinement facility wherein he was detained in solitary confinement for a period of nearly 13 months. Defendant Allen was not ordered or afforded a due process hearing regarding his detention until June of 2023. Nearly 8 months after he was locked away in solitary confinement. 23. Throughout the course of the defendant Allen's detention, the state of Indiana began offering up discovery in the form of incriminating statements made by defendant Allen to prison guards, inmate companions, the warden defendant Allen's treating psychologist, and defendant Allen's family members. 24. Defendant Allen then moved to suppress the admissibility of said statements on the basis that said statements were involuntarily made and thus obtained in violation of defendant Allen's 5th, 6th, and 14th Amendment rights under the U.S. Constitution. Defendant Allen also asserted that his rights under the Indiana Constitution, Article 1, Section 12, 13, and 14 were violated. 25. On August 28, 2024, this honorable court issued the amended order or judgment of the court denying defendant Allen's request for suppression and holding in totality that the statements given by the defendant to the various individuals were not coerced, were voluntary, and were not the result of interrogation by the state or its actors, nor the product of his confinement. 26. With regard to August 28, 2024 amended order, the issues to be addressed are as follows. A. Was Richard Allen denied his right due process under both the state and federal constitutions when he was detained in solitary confinement without having been afforded a timely hearing on the state's motion for safekeeping order? B. Did the effects of the defendant Allen's extended solitary confinement render statements made by him to the prison guards, inmates, companions, the warden, defendant Allen's treating psychologist, and defendant Allen's family members involuntary and therefore inadmissible at trial? C. Were the statements allegedly given by the defendant Allen to his treating psychologist, Dr. Monica Walla, privileged pursuant to IC 3446.3.1? The August 28, 2024 order involves a substantial question of law that could be resolved on appeal and led to a more orderly disposition of the case. Defendant Allen's incriminating statements stemmed from a most unique detention circumstance. Allen nor his counsel were given no choice in the matter. The issue of first impression here is whether or not defendant Allen's due process rights were violated. For example, does the safekeeping statute IC 2533.11.1 require the court to conduct a hearing to address the propriety of defendant's pretrial detention circumstances? Defendant Allen is unaware of any rulings in the state addressing this very issue. If the Court of Appeals were to find in defendant Allen's favor, the admissibility of statements and other evidence stemming from defendant Allen's wrongful detention would be inadmissible. The normal remedy of a direct appeal is not adequate. 27. The remedy of an appeal is otherwise inadequate for all reasons stated herein. 28. Because of the pending trial date, the defense would further request that this court issues its ruling on this motion as expeditiously as possible. 29. The state of Indiana has been contacted and objects to the request, but waives the 15 days to respond, as they have indicated that the prosecution will promptly file their objection. 30. Based upon the pending trial date, the defense would respectfully request this court to rule on this matter as expeditiously as it can, and believes the prosecution would also benefit from an expeditious ruling. 31. This motion is not made to unnecessarily delay the trial, but out of a sincere belief that this court's ruling is erroneous and will result in an unnecessary second trial should Richard Allen be found guilty. Wherefore, Richard Allen, by and through counsel, would request this court to certify the issues presented herein for interlocutory appeal to be heard by the Indiana Court of Appeals. Respectfully submitted, Andrew Baldwin, Brad Rosie, and Jennifer Auger. Certificate of Service and Compliance. I hereby certify that the foregoing document complies with the requirements of Trial Rule 5G with regard to information excluded from public record by Administrative Rule 9G. I certify that this was filed with the court via IEFS on September 9, 2024. I further certify that a copy of the foregoing has been provided to the following by IEFS on September 9, 2024. Nicholas McClellan, Stacy Diener, James David Luttrell, Bradley Rosie, Andrew Baldwin, Jennifer Auger. And this is signed by Andrew Baldwin, the Criminal Defense Team, Baldwin, Perry, and Wiley, at 150 North Main Street, Franklin, Indiana, 46131. There you go. The interlocutory appeal that was just filed by the defense. I'm sure we're going to hear something from the prosecution tomorrow, and we'll read that for you as well. Meanwhile, as soon as I can, I'm going to get to the second part of the Harshman interview from the transcripts of the hearings in August for Richard Allen's case. Thanks for listening and watching. Don't forget to like, subscribe, ring the bell for all notifications, share this with a friend, and leave us comments.